esteemed guests, speakers on the dais, and Mr. Suresh Kotak, who is Executive Committee member of Indo-American Chamber of Commerce, other members of IACC, and guests. Today we have speakers, especially from US. We have Ms. SHASHI PATEL, partner, Ware, Jackson, and Chambers, L.L.P, US. Senior associates, Mr. SAHIL KANUGA and Ms. SHALAKA PATIL from Nishith, Desai associates have agreed to speak to us on international arbitration, a subject which is dear to all of us, and especially to Mr. Suresh Kotak, because he has been an international arbitrator and associated with international arbitration in many years, for many years, and he knows about the works and systems and improvements about international arbitration. He has actually helped in IMC to start an arbitration center, India Center, which is internationally at that level of international systems, and we are expecting a lot of work through IACC, and he has agreed to help us to take it to another level. He is going to chair this session today, and we are extremely happy that he has agreed to, because he's a phenomenal person, and he has himself been doing work in special as an entrepreneur in training of special communities at a very large scale, a very humble human being, and I would like to give a big hand to Mr. Suresh Kotak for coming. Before I speak about the speakers, I would like to speak about our organization. We have All India presence. We have 11 places where we have our IACC members and having different programs. And it's also unique that there's only Indo-American chamber, which is been there for 68 years, looking into commerce and trade between these two countries. With after Modi's presence in US, we know it's going wrong way between these two countries, and we don't want to let go of this opportunity. We want to go on the bandwagon, make sure our organization is the main organization in the country, which actually ties up between both the countries in trade and commerce. And we have a lot of programs in this line, starting of course today, and we had last week regarding international taxation, treaties between US and India. We had none other than the chairman of Central Board of Direct Taxes, who came from Delhi and addressed the gathering and answer all the queries that many people have regarding their investments and taxation. And in future also, we're having many programs, but which will also depend on your interest. Do let us know, and some of you are not members, please become members. You will be very happy and proud to be a member, because there will be a lot of takeaway from being a member of this organization, we promise you. And as per today's program, let me first introduce you to, it's all the way ladies, it's a women power today. You see two speakers who are women, eminent women, and one is Ms. SHASHI PATEL, partner, Ware, Jackson, and Chambers, L.L.P, USA. She has 15 years of experience in this line, and she has worked on complex litigation involving a variety of industries, including pharmaceutical, medical device, healthcare, construction, petrochemical, payment processing, oil and gas equipment, and component suppliers used in oil and gas drilling and production. Certified in advanced arbitration skills. Certified by Regulatory Affairs, Professional Society in US Regulatory Affairs. That's the women part from US. And we have from India, Mr. Sahil KANUGA, Senior Associate, Nishith Desai Associates. Sahil is a senior member of the International Litigation and Dispute Resolution practice at Nishith Desai Associates, a multi-skilled research-based law firm. He has worked on an area of matters including Indian and international arbitrations, as well as advised on corporate and commercial laws, civil and constitutional matters, and criminal offences. Sahil has also negotiated private equity and joint venture transactions. Welcome, Sahil. SHALAKA PATEL, Senior Associate, Nishith Desai Associates. SHALAKA PATEL is a Senior Associate in the International Litigation and Dispute Resolution Practice Group. Our practice areas include international commercial arbitration, investment treaty disputes, alternate dispute resolution and domestic litigation, and arbitration. And she is also involved in advising on out-of-court dispute settlement measures. We welcome all of you for today's function and today's event. And I would be happy that Mr. Porter chairs this session and now takes the program through. And once again, welcoming all of you who have made time for this particular event. I'm extremely thankful. And let's look forward to hearing them. Before that, let me just give them some floor tribute.
So before we start, it would be really great if you could present a bouquet of flowers to our esteemed speakers, Ms. PATEL, Mr. KANUGA, and Ms. PATIL. Mr. KANUGA. And Ms. PATIL.
Today, we are on a really remarkable program. Rajlakshmi Rao, after taking up the presidentship, has tried to activize the programs with a bias on current relevant and needy topics and needy activities. So, I'm so glad to be here on the subject which is of vital importance to India, and not only to India, but all around the world. We have a galaxy of people. The galaxy of people ranges from Shashi Patel, from company called Ware, Jackson, Lee and Chambers, L.L.P, a very big name, but they are doing very big work also. I tried to get some information. Of course, I tried to collect today, but I was told that it is one of the very renowned firm and takes up the multinational work all around the world. Am I right? So, Shashi Ben, the name Shashi means the moon, and I think she will give us a lot of things to know and to practice for our improvement of our arbitration systems. Of course, Nishith Bhai is my friend, and two people from his organization, SHALAKA, PATIL and SAHIL KANUGA, both have come here. And one thing which I read always from literature of Nishith Bhai, that NDA, that is Nishith Desai Associates NDA, NDA, the DNA, research is DNA of NDA. Am I right? This is so if DNA of NDA is research, that means if you look to the booklet, kindly see your booklet in the back. Now if you see the booklet in the back, it is not only with the 10 tips but many more tips. But 10 tips are very important, which we will learn from their presentation, which may be most relevant. But the book seems to be well written, and it is quite compact, complete and quite illustrative. I have just gone through, but I promise that I will read every word of it and send comments to Nishith and all of you. IACC is for not only for the promotion of trade, but for the promotion of relations, and that is what Rajalakshmi Ben does it. And in the first meeting itself, she made clear and made all the committee members committed. You see, they say the committee is for come for tea. She said, no, committee is not for come for tea. Committee is commitment and not come for tea. So, that is the first distinction which was made, and that means she committed everybody to put their best and put the work so that an organization benefits and everybody benefits together. Now, coming to the speakers and subject, now I will not waste time on another frivolities, but I would wish to start the presentation with Madam SHASHI PATEL, and as I introduce, and let us hear what she has to say. I have also to recognize many distinguished people who have come here. Some distinguished people like Kirit Bhai, Captain Gupte, and so many people, Ashwin Bhai. There are a number of people I see whom I know, and I know that they are all experts in not only in the arbitration law, but in the various laws also together associated with it. Thank you very much, SHASHI, on to you.
Good afternoon, ladies and gentlemen. Thank you so much for being here today. I can't tell you how much I am so pleased to be here. I also wanted to tell you that it's a privilege and honor to speak on behalf of the Indo-American Chamber of Commerce in Mumbai, but also on behalf of the Chamber in Houston. I don't know if you know it, but some of these pamphlets were out there, and I wanted to point that out because they also, in combination, have a force and a very big source of information. So, you heard that my name is SHASHI PATEL. You heard I'm an attorney in Houston. You also heard my law firm's name is Ware, Jackson, Lee & Chambers. What you might not know is that our office is in Houston. And I know some of you are familiar with Houston because I just had a bit of a time to talk to you just before our presentation began. I want to point out, for those of you that are not familiar with Houston, it's one of the major centers in the United States for energy, the petrochemical industry, oil and gas, and other industries. It's also the location of one of the world's largest medical centers. And so there's a lot going on in Houston. My firm is focused on civil litigation in the United States, and we do a little bit of litigation outside of the United States. Much of our practice involves business litigation, representing oil and gas companies, the petrochemical business, and other industries, but those are the major ones. We're particularly active in the international arbitration arena, and the way we were introduced into that arena was through our litigation practice. Some of our clients who had experience with us later spoke to us and asked us to help them out in that setting. So just last week, our firm closed a $1 billion transaction for one of our clients, and it was pursuant to an order of the arbitral tribunal in the ICC arbitration that was cited in London. And it was significant because our client was a minor shareholder and the company involved was a methanol company. And the issue in the case was whether our client had been a victim of minority oppression by the majority shareholder. And the tribunal found that it had been. The tribunal then ordered a forced sale of the company to the minority shareholders, our client, and obviously it was a good result. And earlier this year, we got an $11 million settlement for our client in another proceeding, and that was an ad hoc proceeding. And I'm going to tell you a little bit of the difference between ad hoc and institutional, but the setting involved a company that was a nickel smelting plant that was located in Canada. And the parties involved, my party was a small company, or my firm's company, and the other side was a multinational company located in South America. So the case arose out of the construction of the nickel plant in Canada. So you can see that you may have facts in your case that may involve different countries, and arbitration allows you to have a fair venue for all parties so they can feel that they've got a neutral setting. So that being said, let me start by going through our program. And I've got several slides here, but for the sake of time, I'm only going to hit the high points. And I think one of the first things we need to talk about is the definition of what international arbitration is. And so I'm going to read the definition, and I'm going to point out the key points. It's a means by which international disputes can be definitely resolved by independent, non-governmental decision makers, and is pursuant to a written agreement. Now, usually the written agreement comes into play at the beginning of the stage of a contract being entered into. It may be a small paragraph, or it may be a couple of pages or 3 pages, depending on what the needs are of the client. There are situations where there have been contracts that did not have an arbitration provision, and then later on, the companies develop friction and a dispute arises. Now, in that situation, if you don't have a written agreement within the contract, you still can have the option of arbitrating, but both parties are going to need to have to agree to it, and it will have to be documented in writing. So that's an alternative. So you're not prevented from arbitrating if you initially didn't have that planned for. I do want to point out it is not mediation. Mediation is a different type of dispute resolution. I know that there are some particular mediations that may have a definitive resolution of a dispute, but arbitration, international arbitration, has the ability to enforce your award in another jurisdiction. So, so keep in mind, it's different from mediation. There are situations where contracts will require the parties to mediate first, and if they resolve it, that's great. But if they don't, then the next step may be arbitration. Now, it's also not a trial. And I have trial by jury, and I'll explain because I understand India does not have a jury system, but the United States does. And there may be a situation where an Indian client is brought into the US court system. And so it's important for you to know that jury trials are available. But arbitration is different. And it's different in a positive way, because the idea is to be more efficient and more cost-effective than a trial requires. And I'm going to talk about the U.S. system a little bit, because the U.S. system is a very complex system, because you have federal law that may apply. You also have different state law that may apply. So there's several states in our country, and so there may be different laws that will apply. So that being said, let me move on. So why should a company use arbitration to resolve a cross-border dispute? Well, number one, it gives the parties autonomy to decide how they're going to resolve their dispute. It gives you an opportunity to narrow down the issues to what's important to you, and to then streamline how the dispute is going to be resolved. Number two, it's also the idea that it's a neutral venue. Obviously, if I've got a party from the United States, and there's another party that's from, let's say, Switzerland, the Swiss company probably will not want to litigate in the United States because they're not familiar with that law, and they feel that they may not get a fair decision, and vice versa. So this method allows more neutrality, and it helps you with respect to the uncertainty that a hostile foreign court may face. So the third item is very important, and it's enforceability of the arbitral awards. Now, once you arbitrate and you have an award, the arbitrator does not have the power to enforce that award for you. So what you would have to do, once you have your arbitral decision, if you're the party that prevailed, you're then going to have to take that order, go to a court where the assets of the other party are located, and have that court enforce the order. The fourth thing, it's a binding resolution of the dispute. And that's very important because you don't want to go through arbitration or some dispute resolution and then you get a decision, but then it's not something that you can bind the other party to. So that's important. Fifth, the arbitrators or the people making the decisions about the dispute have particular expertise, and that becomes important in industries because some industries are very complex, some facts situations are very complex. So ideally you want somebody that you don't have to teach from the very beginning about the basics, but somebody that has familiarity and then can resolve the dispute. That makes it more efficient. And then, as I mentioned, it limits the discovery that can be done and witness examination. In the U.S. system, it's very broad discovery. It can be invasive, and it doesn't necessarily narrow down to what relevant issues are. So the arbitration proceeding narrows that down. And obviously, there's a lot of cost associated with U.S. discovery, so this narrows the cost as well. In the United States, we have what's called depositions that can be taken of company witnesses. So in arbitration, that usually does not happen. What you will have is a witness statement, and then at the time of an arbitration hearing, that will be your one and only time to cross-examine the witness on the issues. Again, that can narrow down the cost. And last but not least, it can be more efficient and less costly, but only with proper planning. If it's not done properly, it may end up costing you more. And I've tried to make a simple guide for the 10 tips that you may want to discuss with your counsel. I mean, this is not something that's going to allow you to go to do the arbitration, but it will give you an idea of the basics. And so this slide identifies the 10 tips. And I'm not going to spend much time on this because it's in your trifold, and you can go back and look at that. But I am going to hit on the high points. So the first one I want to hit on is number 2. So the scope of arbitration. This is extremely important because even if you have the intention of arbitrating a dispute that may arise, at the beginning of your contract, you can't possibly know what disputes are going to arise later down the line. So you want an arbitration clause that's, well, you may want a narrow one, but you may actually want one that's very broad so that if you have a broad arbitration clause, it gives the arbitrator power to hear practically any dispute that may arise. It might not be all, but practically everything. If you don't do that, then you risk having, let's say if you have a narrow clause, you risk that only those issues will be heard by the arbitrator, and then the other side may say, well, your other claims aren't covered by this arbitration agreement, so the arbitrator does not have the power to hear them. So this is an example of a broad arbitration clause. It's just an example. You would usually take an arbitration clause, and your attorney would then, may add to it or take away from it based on the particular facts. But in this one, I want to point out the language that makes it broad. If you look at the end of the first line, it says, any dispute or difference of any kind whatsoever arising out of, relating to, or in connection with this contract. Now, for those of you who are not lawyers, you may think that that's just duplicative. But from the legal standpoint, there is case law, at least in the U.S., that says that you need all of those words to make it cover anything that could possibly be out there. Now, you will see in this one that we also mentioned that it does cover contract disputes, but not only contract disputes, tort, which is an injury, statutory claims, or any other claim that may arise. So this is something you want if you're wanting to actually arbitrate. Now this is just a slide that shows you if you didn't have a broad arbitration clause, there may be claims that are brought in your case that would require those issues to be determined by a court. So then you have arbitration happening, and you also have to go through the court system. So obviously that's not as efficient as you would want it to be. And you will also incur additional costs. So I also want to talk, this is number 3, the arbitral forum. And the reason that's important, you have options. One is the institutional route, the other is ad hoc. Now, institutional means that you will have one of the many institutions out there that are available who will administer the arbitration. They will help you to, for example, pick an arbitrator. They may help you in setting forth deadlines. They have rules that you have to follow if you have arbitrate under their institution. So it's uniform rules and procedures. So it helps you to not get sidetracked and go through things sufficiently. The third item I do want to mention, the judicial deference to an award. Some of these institutions have been around for years, and so court systems feel comfortable that if a dispute has been arbitrated in that setting, then they feel comfortable that they can sign off on that. So that's why that's a positive. But there are disadvantages to the institutional. The work that they do doesn't come free, and they have fees, and so those can be costly. There's less flexibility because they do have rules and they want you to proceed pursuant to their rules, and there can be procedural delays. For example, in ICC, you may get an award from the arbitrator, but then you have to have that approved, and it also may come back for further resolution. So there could be procedural delays. Now, ad hoc is different, and there's greater flexibility. That's the positive. So the parties may be able to avoid having to go through a lot of things you have to go in the institutional setting and just focus on the positive things that are relevant to your case. So another positive that people like, it's supposedly less costly because there are no administrative fees that you see in the institutional route. But the disadvantages are this. Our ad hoc usually only works if the two parties are working together. If they're not going to work together, you're not going to come to a decision on anything. And that's just going to delay the process, and then you're going to have someone from the outside come in and help with that. So that's where the costs start incurring. So it can be positive and negative. And this right here, I just gave you an example of some of the institutions that are out there. There's the ICC, the London Court of International Arbitration, the International Center for Dispute Resolution, which is an American Bar Association organization. The Singapore, I understand that many companies in India do arbitrate in Singapore. And then the next one's Hong Kong. I've got China down here because China's becoming a place where many arbitrations aren't happening, and because the government in China requires them to arbitrate there. And then some of the others, there's the World Intellectual Property Organization, and that would be for disputes relating to patents and trade secret type of claims. And then the ICSID, that's the banking industry, and also governmental claims that arise. And then the last one I've got on there is the Stockholm Institute. But again, there are many more. The next thing I want to discuss is choosing your seat of arbitration. Now this is really important because it's where the arbitration, the arbitrators, the rules that the arbitrator must follow, legal rules, will come from wherever the seat is. So you want a seat that's going to be efficient and give the arbitrator the power he or she needs to resolve a dispute. If you're in a setting where the court system is going to micromanage the arbitration, then you see where the inefficiency may arise because you're not only having the arbitrator decide something, but then you have to go into the court system. So now that we have the New York Convention, there are, I think, 148 countries that are signatories, including India, which is a positive because that means that if you are in a setting that is a signatory to the New York Convention, those are recognized by those countries. So there's less interference by the court system. Okay, so I want to move on to talk about this case. In September of 2012, and my colleagues may talk about this more, but there was a ruling by the Indian Supreme Court in the case called Bharat Aluminum versus Kaiser. And this was significant because before this time, the courts were interfering in awards that were made outside of India in international arbitration. And so you see, you've got a court system that's second guessing what the arbitrator has decided, and again, it can then put you in the court system and it becomes less efficient, less costly, more costly. So that's why that's important. And it's positive because, as you know, Prime Minister Modi and President Obama have recently met, and part of the positive of that is that both recognize that it's important for both countries to have positive international trade. And I think a lot of companies feel more comfortable knowing that if they do have arbitration, that the country that they're arbitrating with will also honor the arbitrator's awards and will not be second guessing. So it's a positive towards having international trade and not hindering it. And I think before this ruling, there was a little bit more concern about whether they could do that. So it's opening the doors more. So I only have a little bit more time, so let me move on to number 10. And I think these slides, if, for example, you would like a copy of these slides, just email me and I will be happy to provide them so you can have it all. I don't want you to feel like I took something away from them. But tip 10, as I mentioned at the beginning, all of this is only going to be efficient and less costly if once you do get in the arbitration setting, you are efficient and are, from the beginning, looking at what needs to be done, what the issues are, what evidence you're going to need to support your case, because it's not going to help if you wait until halfway down into the arbitration and then you start doing that, because the next slide is going to just basically tell you what the steps are. To initiate the arbitration, you have the person that starts it, and that's called the claimant, and they request the arbitration. And once that's done, that claimant at that point should know what issues they're going to raise, what the evidence is they're going to use, what documents that may support it. And then after that's done, you're going to have a respondent. That's the person answering the request for arbitration. And in addition to answering the request for arbitration, they may also have a counterclaim. So that's their claims that they may raise against the claimant. So at that point, I would hope that they would have also talked to their witnesses, figured out what their side of the story is. After that happens, the parties are going to appoint an arbitrator. And there may be one, there may be more than one. The usual number is either 1 or 3. And 1 is obvious. Either the institution chose the arbitrator or the parties agreed upon that one person. When you have 3, it's a situation where one party selects their arbitrator. They feel like that's the person that they believe would be fair. The other party selects their arbitrator, and then the 2 decide on the 3rd. And so it's believed that can be a more, people feel like it's more fair, somebody's going to hear them, and then it's a matter of proving their position. And they will prove their position at the next step, they'll have a preliminary hearing. And as I said, prepare, because at that preliminary hearing, you are going to decide what the deadlines are going to be, you're going to decide what you need to do to support your case, and if you don't know, then it's not going to be efficient. And I presume your opposing party will be up to speed at that point. So to have a fair advantage, you need to be prepared. And then the next step will be to exchange information, get ready for your hearing, and then you'll have a hearing. And after the hearing, the arbitrator will be in a position to start making a decision, but there may also be what's called post-hearing submissions. So those are legal documents that are filed, motions that are filed with the court, I'm sorry, not with the court, but with the arbitral institution or arbitrator, and they may be on legal issues that arose in the case and may affect the decision. After that happens, you have the award. And as I mentioned earlier, you will have to take the award if you're the one that prevails and go to one of the countries that is a signatory, and hopefully that's where the asset is. And then hopefully the court will agree and sign off on the order, and then you go after the assets. And last but not least, and that's the enforcement step that I have there. So that's it for now, but I've got this, I wanted to introduce you to some of our other lawyers at our firm. The woman on the far left, near the wall, she is a former judge, and so she's a great asset to our team. She has actually been asked to be an arbitrator as well. And then we've got some of our other partners and associates. And right next to me, there's a gentleman with the same last name as mine, PATEL, but we are not related. And for a law firm of a medium size like ours to have two PATELs, it says something. But anyway, I thank you very much. And I know we're going to have questions, but we're going to have those at the end. So I will pass on to my colleague. And I thank you very much for your time. And I do want to say thank you to the women who put this event together. It's so organized, and I want to recognize Wankhede and I'm going to pronounce it right. Churchgate. It's Sneha and Danita and Marsha. So thank you very much. Oh. Thank us as well.